I want to take a few minutes to talk about professional practice and some of the considerations that go into being a professional in the social work field. You'll get exposed to many of these concepts, perhaps all of these concepts, and other coursework during the course of your social work education, but I think they're particularly useful to consider in the context of working with families involving intimate partner violence. First of all, accreditation. Social work programs in universities and colleges are accredited by the Council on Social Work Education, the CSWE. Each school has to undergo a grueling series of challenges that include providing extensive written materials that conform to accreditation standards regarding curriculum, admissions, and faculty educational achievement, as well as library facilities and holdings and community acceptance. Accreditation assures potential employers as well as the public in general that an individual who graduates from a CSWE accredited School of Social Work, either on the bachelor's or the graduate level, has received appropriate content in their educational curriculum to prepare them for work in the social work field. It's one of the reasons that I think having a social work degree is a very wise choice when you're out there marketing your skills as a helper. The accreditation process in social work assures students and employers that all accredited programs will have similar curriculums and experiences for student learning. If you transfer to another university or you apply for grad school in another university, at times they may ask for copies of not only your transcript, but also syllabi from different courses to ensure that the content in each of those courses covered basic requirements that are CSWE suitable and also that meet the new school's requirements as well. And so that's why I say sometimes it's wise to keep your syllabi handy or recorded somewhere so that you have them to share if you need to. Most states, including Alaska, require that BSW and MSW level social workers be licensed. This doesn't mean that if you have a social work degree and you want to work in a helping field, you have to have a license, but it does mean that you cannot call yourself a social worker. You can say you have a social work degree, but you can't call yourself a social worker in your job. That's title protection, which is partly to protect the profession from individuals who are inappropriately trained calling themselves social workers, but also to provide some assurance to your clients that you know what you're doing. Licensure includes accumulating a certain number of supervised hours after graduating, usually 2 years of full-time practice, or if you're working part-time, a total of 1,500 hours, during which time you are supervised by a licensed or licensable social worker. You can also be supervised at times by individuals who have doctorates in psychology, for instance, and such. That was, in fact, how I got my license many years ago. If there isn't a licensed or licensable MSW in your place of employment, you can contract at times with licensed or licensable social workers out in the community to provide you supervision. In addition to the supervision requirements and the practice requirements, you also have to take a written exam, and in some cases, not including Alaska, you may have to take an oral exam. Most states also have a reciprocity agreement so that if you are licensed in one state and you move to another state, you can transfer your license to the other state without having to go through the whole process all over again. The purpose of licensure is also to protect clients by making certain that licensed social workers have the knowledge, skills, and values to perform effective and ethical social work practice. Social work has always stressed the need for others to review our work, and so you should develop a professional relationship with a more experienced social work practitioner who you consider to be a mentor, or with your agency supervisor, or both. Supervisors review our work and take legal responsibility for the work that we do and suggest ways to do our work more effectively and efficiently. If your supervisor at times seems to have a controlling hand in the supervision that he or she performs with you, keep in mind that not only are you responsible legally for the work that you do, but so is your supervisor. Supervisors make recommendations for promotions and salary increases. They review your work and do periodic evaluations of your performance, and they act as the agency's assurance to the public that the quality of your work is at its highest possible level. Once you're licensed as a clinical social worker, you're no longer required to have supervision, by law at least, but it's still recommended highly because you need to have outside input into the work that you're doing and to have someone to sit down and talk over things related to cases with. If you have a private practice, it's highly recommended by me at least, as well as many other people, that you contract with somebody to provide supervision or consultation or both in your cases. Those are some of the general considerations about working in the field. Now the rest of this talk will be focused upon duty to warn. It's something that I think is very, very important for you to be aware of. And if you've heard this before, listen further because there's always new information. I want to read you a brief summary of the Terrasoft case, which much of our focus upon duty to warn arises from. I think it's useful for you to know what exactly the Tarasoff case was all about. This goes back to the 1960s, and the ruling by the court was made by the mid-1970s. In 1967, Prosenjit Padar, a graduate student from Bengal, India, came to the University of California at Berkeley. In the fall of 1968, he met Tanya Tarasoff at folk dance lessons in the International House where he resided. They saw each other about once a week until New Year's Eve, when Tanya kissed him. Padar interpreted the kiss as a symbol of the seriousness of their relationship. When he explained this to Tanya, she replied that he was wrong and that she was more interested in others than in him. This rejection caused Padar to undergo severe emotional crises, during which he became withdrawn, ignored his studies, stayed alone often, and wept frequently. His condition continued to deteriorate until he began to visit a campus psychologist. Sometime later, in the summer of 1969, when Tanya was apparently on vacation to Brazil, he confided to the psychologist that when she returned, he was going to kill her. The psychologist believed Padar and notified the campus police, requesting that they have him committed. They briefly detained him, but he was released because he appeared to be rational and promised to stay away from her. The patient terminated therapy because of subsequent attempts to hospitalize him. At the order of the psychologist's superior, a psychiatrist, no further steps were taken to commit Padar or warn Tanya. In late October 1969, Padar went to Tanya's home to talk with her. She wasn't home and her mother told him to leave. He did, but he returned later that night with a pellet gun and a butcher knife. He said he wanted to speak with her, and she began to scream. He then shot her with the pellet gun. She ran from the house. Padar followed, and catching her, stabbed her repeatedly and fatally with the butcher knife. Tanya Tarasoff's parents brought suit against the psychologist, his superior, the campus police, and their employer, the University of California, for failure to warn them, Tanya, or anyone who could have reasonably been expected to notify Tanya of her danger, and for negligently failing to confine Padar. After having their suit dismissed for failing to state a cause of action, they brought their appeal to the California State Supreme Court. The Supreme Court concluded that all defendants, including the campus police, were immune from suit for failure to act properly to convince Padar on the basis of a California statute. However, they did rule in a December 1974 decision, now this is 5 years later, they did rule in a December 1974 decision that the psychologist had a duty to warn a potential victim. The decision was withdrawn after a tremendous reaction to it by the psychiatric community. It took the court an additional 18 months to reissue the decision in different language, and in 1976, the decision that was issued was still very similar, though not identical, to the one issued in 74. In a 5-2 decision, the court held that when a therapist predicts that his patient is a danger to another person, he has a duty to warn that person of that danger. 4 of the 7 justices went even further, holding that, in addition, if a therapist should have made such a prediction on the basis of professional standards, quote, he bears a duty to exercise reasonable care to protect the foreseeable victim of that danger. The majority of the court held, quote, our current crowded and computerized society compels the interdependence of its members. In this risk-infected society, we can hardly tolerate the further exposure to danger that would result from a concealed knowledge to the therapist that his patient was lethal, unquote. That's a quote from the Tarasoff versus Regents case that's noted here on this page. Since the Tarasoff ruling, there's been a widespread understanding among social workers and other professionals in our field that disclosure of confidential information requires evidence that would reasonably prevent serious, imminent, and foreseeable harm to a client or other identifiable person. I want to take a moment to mention, we're talking about the situations where a client is perceived to be a danger to others. Remember also that you have a duty to act if the client is perceived to be a danger to self as well. And also, if you become aware of information that the client is being abused as a child or is abusing a child or neglecting a child under child need of aid statutes in your state. However, this is focused on the duty to warn when the client is perceived to be a danger to others. This principle is an exception to the general principle that the social worker shall not disclose any information about a client acquired from or revealed in the course of or in connection with the performance of the social worker's professional services. That's the confidentiality provision. The exception requiring the social worker to disclose the client's confidential information occurs when there is, quote, an explicit threat to kill or inflict serious bodily injury upon a reasonably identified victim or victims, and the client has the apparent intent and ability to carry out the threat, unquote. The decision to warn or not warn a third person creates a dilemma for a clinician between an ethical and legal obligation to maintain confidentiality and the same obligation to warn third persons of potential harm to them. The potential for a difficult outcome to either decision is great, and it becomes imperative for workers in making thoughtful and careful decisions to keep well-documented records and to be consistent with the law. Document, document, document. It is so very important in these situations. At points, what may be most helpful for everybody concerned is for the worker to seek consultation. And again, of course, document that consultation. Since the mid-1990s, though, a series of national tragedies has shocked the nation's conscience and has led to an intense debate about traditional Tarasoff and Code of Ethics guidelines. We'll get to some of those cases in a moment, but first, a little bit about duty to warn. Many social workers are unaware that duty to warn laws vary from state to state, and that a few states have not established a statutory duty to warn. Understand the Tarisoff decision was a ruling by the California Supreme Court. Now, that doesn't mean that it doesn't apply in other states, but it may in some ways limit its applicability nationally. 22 states have statutes applicable to social workers that establish a mandatory duty to warn. A number of the states that are listed here, though, have court decisions that have interpreted the duty to warn laws. A permissive standard, a second group of states, gives permission in state statutes for social workers to warn of serious threats, and Alaska is considered to be a part of this group. In some states, like Texas, the permission to warn is limited to notifying medical or law enforcement personnel, not the threatened person or persons. That is not the case in Alaska. Now, while we have permission to warn, another consideration would be, that is under the statutes, under the law, another consideration may be your ethical and moral obligation to protect other persons, and perhaps your legal responsibility as well. And so, while this is a permissive standard legally speaking, we probably ought to consider duty to warn mandatory. A third set of states doesn't provide any statutory language for social workers addressing duty to warn, but some of these have implemented the duty through court decisions. So there's a few states here who don't have statutory provisions, but have established a duty to warn through court decisions. There are a few states here, 6 of them, that are silent as to the social worker's duty to warn. Again, that doesn't mean there isn't a duty to warn, but it just means, legally speaking, that doesn't exist in those states. A small number of states have statutory language or court decisions that might be interpreted as limiting the duty to warn, including Alabama, Guam, and North Carolina. So there are some limitations on duty to warn in a few states. Now, I referred to some of those cases since the 1990s that have kept this issue on the forefront, and these and other widely publicized cases have included allegations that people with a known record of mental illness went on to commit mass murders and assaults. Wendell Williamson in 1995 fired a rifle at people in the streets of downtown Chapel Hill, North Carolina, and killed 2 people. He was, I believe, diagnosed as schizophrenic. He was sentenced to prison. I think he was declared to be incompetent, but spending his life in an institution. Sung Hui Cho, an undergraduate student at Virginia Tech, shot and killed 32 people and wounded 15 others before taking his own life in 2007. Jerry Lee Loeffner killed 6 people and left 14 people injured, including Congresswoman Gabrielle Giffords in 2011. James Egan Holmes, a former University of Colorado graduate student, killed 12 people and injured 58 others at a movie theater in 2012. Holmes was eventually found guilty, was sentenced to 12 life sentences plus 3,318 years without parole. He had been experiencing, by the way, issues since middle school that were mental health related. Adam Lanza shot 20 children and 6 adults and killed them at Sandy Hook Elementary School in Connecticut, including his own mother, by the way. He had had developmental issues since the age of 3, was diagnosed at various times with varying types of conditions related to autism spectrum disorder, OCD, and his father was quoted as saying that he thought he might have been schizophrenic as well. He was also appeared to be anorexic. He was 6 feet tall, weighed 112 pounds at the time of his death. Dylan Roof, a young white supremacist, was convicted of killing 9 African-American worshipers at a church in Charleston, South Carolina in 2015. He had been socially withdrawn and experiencing some mental health issues for a number of years. And more recently, Nicholas Cruz killed 17 people at Marjorie Stoneman Douglas High School in Florida in 2018. I don't think that trial has happened yet. He had been the client of in-home services, as I recall, prior to the time that this shooting occurred. So all of these cases, I think most of them had received treatment at one point or another and had been evaluated at different points. Of course, we don't have the ability to predict the future when we work with individuals, and so it's difficult to point to anybody's therapist or in-home counselor or evaluator and say they failed to prevent an identifiable tragedy. But this just serves to demonstrate that sometimes the clients that you're working with who have a varying degree of issues and problems oftentimes have bigger things going on, and it's very, very important to keep this in mind as you work with individuals. National standards are shifting related to workers and other behavioral health professionals' ethical and legal duties when they're concerned about risks to the public that clients may pose. There was a decision by the Washington Supreme Court called the Volk decision, is something you might want to read up on, that overturned a trial court judge in a case that had held that the judge was in error by using the widely embraced standards set by Tarasoff, requiring clinicians to take reasonable precautions to protect only when a client poses a threat to an identifiable potential victim. The Volk decision broadened professional duty to warn by changing the obligation for notification to a reasonably identified victim to the new language of all foreseeable victims. There's been a lot of fuss and concern about that decision, but that was what was decided in Washington. And in 2017, I think the Volk decision, by the way, was in 2018. In 2017, the task force charged with revising the NASW Code of Ethics removed the long-standing expectation that workers have evidence of an identifiable potential victim to justify disclosure of confidential information without client consent, protecting others from harm. According to the current standard, the general expectation is social workers will keep information confidential does not apply when disclosure is necessary to prevent serious, foreseeable, imminent harm to a client or others. So what do we do about all this? What are some of the implications? Well, there are a few implications here that I want to talk about. And one is that social workers would be very wise to take a close look at their current risk assessment protocols. To protect others from harm and as well to prevent malpractice claims and ethics complaints, these are some of the things that workers ought to be doing. First of all, conduct a thorough assessment of risks of harm to others that your clients pose, including any plans the client may have and the means to carry out the threat. Discuss with your client the plans that they have to keep other treatment providers and members of their support network informed of known risks. Become thoroughly familiar with relevant federal and state laws and the Code of Ethics standards concerning disclosure of information in these cases. Develop with a concerning client a plan that includes more frequent contact and enhanced services as needed. Identify emergency contacts and community resources. Schedule periodic, repeated risk assessments. When warranted, consult with colleagues about possible disclosure of confidential information. And again, document these steps and actions that you take. Documentation can be very important and can save you from lawsuits and malpractice concerns later. But it's also vitally important that social workers recognize that the majority of people who are living with mental illness do not pose a threat to others and do not commit serious assaults and murder. Because a client has a mental illness does not mean that they're violent, and in fact, the vast majority of them are not. The majority of people who have committed mass shootings hadn't been diagnosed with a major mental illness. Consider, for instance, the Las Vegas shootings, which was one of the largest number of people who were killed and injured a few years back. And as far as I have heard so far, the individual that did that shooting was never brought to the attention of mental health authorities and never had any mental health concerns. Sometimes there really are no signs ahead of time. A substantial body of research demonstrates that behavioral health professionals' ability to predict whether an individual client will engage in violent behavior is quite limited. You aren't a soothsayer. We don't have a crystal ball. We can't predict the future. We are, however, responsible to take professional steps to ensure that our clients, who may be a risk to others, have certain safeguards in place, and to notify others if indeed this person is deemed to be a threat to others. Recent developments related to the social worker's duty to protect obligations are yet another reminder that ethical standards aren't carved in stone. They evolve, often in response to broader cultural developments. But the primary lesson here is that it really behooves us to pay close attention to evolving ethical standards in the profession and to adjust our policies, practices, and protocols accordingly. Some good things to think about here and to keep in mind as you go about your work. Let me know if any questions arise from this discussion. Thank you.